First matter the court will call is Baxter County criminal case CR 2018-471. This will be State of Arkansas versus Tina Snyder. Ms. Snyder, you're appearing this morning for arraignment on charges of residential burglary, which is a Class B felony, theft, 2 counts of theft of property, Class D felony, and then 1 count of Class A misdemeanor theft of property. Those are the charges against you. Have you made any arrangements to be represented by an attorney?
I've tried. I signed up for a public defender.
Okay. You filled out the application?
Yes.
When did you do that?
About a couple days ago.
Has the public defender's office received that
We
application?
have not, Your Honor, we have been over there also. This morning we were there.
Okay. Well, so I guess what you need to do is fill out another one and make sure it gets into the hands. Apparently, the public defender's personnel have been over there to the pickup place, and for whatever reason it wasn't there, or they couldn't find it. So I'm going to put down that you're applying to the public defender's office on the charges against you, which, as I say, are residential burglary and 3 counts of theft of property. On those charges, how do you now plead?
Guilty.
No.
All right. Well, I understand the plea you're entering. I'm going to change that to a not guilty plea.
Not
If
guilty.
I accept your guilty plea right now, I'll go directly into sentencing, and you could be sentenced.
Not guilty.
Yeah. All right. I've noted a plea of not guilty. All right. Your case is assigned to the Division III docket of Judge Putman.
Can I get?
Pardon?
Can I get a bond?
Well, we're not there yet. I'll
Okay.
take up bond in a minute.
Okay.
You're on Judge Putman's docket. He will be here on November 8th, and I'll order that you reappear in front of him on November 8th. Now, let me check on the issue of bond. Okay, the initial bond setting on this matter is $20,000. What says the state to, I assume she's asking for a reduction in bond?
In our position to state this is a residential burglary case where someone's home was broken into by this defendant. We believe that bond's appropriate based on the actions taken by the defendant in this matter.
Okay. Court's going to leave the bond where it is at this time, subject to being readdressed in front of Judge Putman once she has counsel in place on November 8th. So that's the bond at this time, $20,000. You may be excused. 2018-470, State of Arkansas versus Blaze Forrester. On the new case, the court is making the appointment of the public defender's office to represent Mr. Forrester on the charges in this case of battery in the 2nd degree, a Class D felony, and terroristic threatening, a separate Class D felony. How does the defendant now plead?
Your Honor, he pleads not guilty.
Based on past history, I'm anticipating that there'll be a motion for evaluation filed.
Yes, Your Honor, there will be.
All right, Mr. Forrester, the court would advise you, you sent me while you've been incarcerated a substantial number of postcards asking various things and pointing out various things. The court is not writing you back because I'm forbidden by the rules of ethics, judicial ethics, from having direct communication with a defendant before my court. that would be what's called ex parte communication. As long as
Okay.
you're represented by an attorney, my communication with you will be through your attorney, and that will remain the case. You feel free to continue to send postcards to me if you wish, to make me
Okay.
aware of things. I will assure you I've read every one of them, and I've discussed them with your attorney in every case. I've also discussed them with the prosecuting attorney's office, and all of us are very concerned about the fact that as yet you haven't been transported to the Arkansas State Hospital for treatment on the original case that you were before this court. There's an order in place that directs that, and it hasn't been acted on except in a limited fashion of sending you a counselor to counsel you while you're in jail. The prosecutor has in fairly specific terms suggested that that's an improper response to the court's order, and we're expecting something to change very, very soon. So I just want to assure you that your concerns and that you've expressed are being addressed and noted when you make them, and we're addressing those.
Okay,
That will continue to be the case. All right?
Did you get the one about me being punched in jail?
Yes?
Okay, all right.
All right. You may be excused at this time.
Thanks.
Court will call next 2018-473, State of Arkansas versus Tenney Schuyler, or Schuyler Tenney, excuse me, and 2018-344, Schuyler Tenney. Ms. Tenney, you're before the court today on two separate matters. The first is there's a petition to revoke in case 2018-344, where you were put on probation. There's been a petition to revoke filed. First of all, it alleges that you, on October 29th of 2018, violated your terms and conditions of probation by being found in possession of drug paraphernalia, and secondly, you also violated the term of condition that involves having any items of drug paraphernalia or anything related to controlled substances. So you're going to be arraigned on that charge. Separate from that, we have 2018-473, where the charges against you are possession of drug paraphernalia, methamphetamine. That's a Class D felony. Have you made application to the Public Defender's Office?
Yes, Your Honor.
When did you do that?
I just turned it in yesterday.
Okay. But again, I think we need to check with the sheriff's office over there where those applications are going, because the Public Defender's Office was over checking and didn't find one today. If we haven't found, if they aren't easily found, you need to make a point of filling out another one, turning it in, and make sure that we were able to appoint the Public Defender's Office to represent you. In any case, on the charges against you in case 2018-473 of possession of drug paraphernalia, Class D felony, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. in case 2018-344, where the charge were the ones essentially it's the same charge because that's the basis of revocation is that you broke the law. On that charge, on the revocation, how do you now plead?
Not guilty.
Okay. I'm noting that plea on the record. I'm going to transfer 2018-473 to the Division 4 docket so that the two are consolidated on one docket and can be dealt with together. So the court will order the transfer of 2018-473 to Division 4. It's currently assigned to Division 3, that is Judge Putman's docket, unless you have some objection to that.
Yes, Your Honor. Is there any way I could get a bond?
Okay, we'll discuss that in a minute. You
Yes,
don't have
sir.
an objection to the transfer, do you?
No.
Okay, very good. So we'll both cases will be set on my docket. I'm going to set the revocation case down to be heard on November 29th. I'm going to set the new case down on a trial schedule, on my trial schedule, which actually sets it for trial in the week of June 24th, 2019, and sets it for a plea deadline of March 21st, 2019. And then I'm going to set it down for just an reappearance on that November 29th date as well. It may be possible. I'm just suggesting that it may be possible to resolve everything on that date. If possible, I hope to do so. That'll be the order of the court. Now, the question the court has in terms of this matter is, being on probation isn't that difficult. You just have to show up and follow the rules of probation. And possessing drugs when you've been convicted of or possessing drug paraphernalia when you've been convicted of drug paraphernalia, it's a pretty, I would think, a pretty common sense matter. You can't have that stuff and remain on probation. And so at this point, let's see, where is the bond set on that?
$2,500, Your Honor. Your Honor, the state's concern on Ms. Tenney is we just sentenced her back to end of August on similar charges and trying to help her out. We are concerned that if she is out, she will continue to do what she's doing and not get herself clean. That's the greatest risk. She'll continue to reoffend by using drugs, Your Honor.
I'm concerned with the same thing. What I am going to do is I'm going to set a bond of $5,000 to cover both cases. That bond will be it'll be a cash or professional bond. It will be conditioned upon no use or possession of drugs or alcohol. And I will tell you right now, Ms. Tenney, if you violate that condition of the bond, you will be back in jail with no bond at all. I don't know why you didn't understand that you couldn't have drug paraphernalia in your possession when you were put on probation just 2 months ago. But if you didn't understand it, I hope I'm making it clear now. You are not allowed to have any drugs or any alcohol or any paraphernalia related to drugs or alcohol in your possession. And that as a condition of this bond, if you make the bond is being up from $2,500 to $5,000 to cover both cases. If you do make that bond, it is your responsibility to be in, first of all, to be in court on November 29th. Secondly, it's your responsibility to get in touch and stay in touch with the Public Defender's Office. If we can't find your application before you leave the jail, fill out another one, turn it in, and get that process started. As soon as, if you do get out of jail, as soon as you get out of jail, within 24 hours, you need to contact the public defender's office and make arrangements to get in to see them. Failure to do that, because I'm ordering you to do that, failure to do that will result in your being held in contempt of court and put back in jail. If I need to just keep putting you in jail so you'll understand what rules you're under, you're not like everybody else. You're already on probation, and you need to be, the third thing you need to be doing is you need to be checking in with probation and complying with all the rules of probation. So those are the 3 requirements on you after this court appearance here today. You understand?
Yes, sir.
You may be excused. 2016-364, State of Arkansas versus Carla Thompson. Court's making the appointment of the Public Defender's Office to represent Ms. Thompson. Ms. Thompson, you're before the court on a petition to revoke that was filed back May 18th of 2017. The petition to revoke alleged that you had violated the terms and conditions of probation in failing one in May of 2017. You failed to report as scheduled for a visit with your supervising officer. Secondly, it's alleged that again in May of 2017 that you no longer live, it was determined that you no longer lived at the address you had reported as your address, and you'd failed to notify your supervising officer of change in address and failed to keep your supervising officer informed of your current address. It's also alleged in that same month that the officers determined you were avoiding all contact with ACC officials and you had absconded supervision. So those were the allegations contained in the petition in this matter. Where are we at this point?
We're going to have a final disposition. Ms. Thompson is going to change or enter a plea of truth, and the state is moving to convert this to a contempt, 89 days credit for any time served. In addition, Your Honor, the state has agreed that since she is gainfully employed at Skipper's Restaurant here in Mountain Home, that she could serve her time on the weekends.
That is correct, Your Honor.
All right. Ms. Thompson, do you understand what the agreement is in this case?
Yes, sir.
And are you willing to change your plea on, are you willing to enter into that agreement and change your plea on the allegations against you?
Yes, sir.
The allegations against you are being amended or modified by the state from a petition to revoke your sentence based on your failure to comply with terms and conditions of probation to contempt, meaning contempt is what that means. Contempt of court is the failure to comply with a court order. The court order in this case being the same court order that required you to comply with the terms and conditions of probation. But on contempt, you're prepared to enter your plea, is that correct?
Yes, sir.
Have you discussed the terms of this agreement with Mr. Cooper, and do you feel you understand what the agreement is and the punishment you're to receive?
Yes, Your Honor.
You therefore understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand, and on the charge of contempt of court, how do you now plead?
Guilty.
You're entering, you're admitting you're entering a plea of guilty to contempt of court. You understand that by pleading guilty, you give up certain constitutional rights you have in case of contempt of court or even probation revocation. What you're entitled to by law is a due process hearing in front of the court. It's not a trial by jury, but it's a due process hearing in front of the court. At that hearing, you'd be entitled to be represented by an attorney and assisted by an attorney throughout the process. You'd be entitled to call witnesses of your own, and you'd also be entitled to confront the witnesses who appeared and testified against you. And finally, after that hearing, you'd be entitled to appeal. All of those are rights that you have that you give up by pleading guilty. Do you understand that?
Yes, I understand
And
completely.
understanding what rights you're giving up, are you still willing to enter this plea
Yes, sir.
of guilty? Are you pleading guilty here today freely and voluntarily?
Yes, Your Honor.
Has anybody in form or fashion forced you into this plea?
No, sir.
As you enter this plea, are you admitting to the actions that constitute a violation of the court's order? That is, that you failed to report, failed to notify of a change of address, and that you had ceased making contact with your probation officer?
Yes, Your Honor.
Based on that, the court's going to find that Ms. Thompson has freely and voluntarily entered a plea, done so after consultation with her attorney, and has admitted to her actions that constitute a violation of the court's order. On that basis, the court finds that she's in violation of the court's order and will sentence her, therefore, in contempt of court, and will find her in contempt of court and sentence her to 89 days in the Baxter County Detention Center. She'll be given credit for any time she has already served, and she will be allowed to serve the remainder of the time in weekend installments in order to continue to be employed. That'll be the order of the court.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. You may be excused. Two 2018-458, State of Arkansas versus Rebecca Payne. All right, court's making the appointment of the Public Defender's Office to represent Ms. Payne. Let's see, where are we on this? Ms. Payne's case is set by scheduling order for trial on June 24th of 2019 with a reappearance on March 21st of 2019. And today's date was, is this, let me go through and make sure we've got an arraignment done. She appeared in front of Judge Putman on October 25th and entered a plea of not guilty to the charges, and then was ordered to reappear here today. So she's been arraigned on the charges, and that's, and we've entered our scheduling order. So your next appearance in court is March 21st. If you bond out of jail, the court is advising you that you're under an order of this court to report to your attorney and get in touch with him. What you do as soon as you get out of jail is you call the Public Defender's Office, make an appointment, and then keep that appointment and get in to see him. You're ordered to do so if you bond out. If you don't bond out, of course, we'll stay
I
in.
can't bond out. I have no money.
All right.
I have no disability, so I can't bond out.
All right. Well, then, while you're in jail, I'm confident the Public Defender's Office will come and see you and discuss your case.
Your Honor, so she'll know, she is brand new to us. Mr. Chisholm and I have had some discussion about her case, and I'll get over to see her. It will not be today or even tomorrow, but when I'm over there next week, I will talk to her about what Mr. Chisholm and I have talked about today.
All right. All right. If you get a date, I mean, if you get any type of agreement worked out, she can appear on any of my next few dates. All right. You may be excused at this time.